Good evening, everyone. Thank you so much for joining us tonight. We are recording. We'd ask you please to stay on mute until the question and answer session at the end. If you'd rather ask your question via the chat, there's a function at the top in the middle. Please put your question in there at any time at all during the talks and we'll answer it later on. I can see from looking at the list of names of people who've joined us so far that many of you know us all pretty well, but some of you may not know all of our speakers tonight. My name is Mary Cowe, and I'm pleased to introduce you to Nick Lee, who's there waving, and Alistair Haggerty.
Hello, good evening.
As many of you know, there are 26 criminal barristers practising from Guildhall Chambers, prosecuting and defending serious crime of all types, but the three of us represent a subgroup of a little over a dozen of those practitioners who have a particular specialism in fraud and financial crime. Fraud, it's everywhere it seems. Whilst it's the most prevalent offence in the UK, believed to account for 40% of all offences, it's not been treated as a policing priority, which probably won't be news to any one of you. I've put on this slide the fairly stark statistics concerning the low number of cases which are even sent out for investigation by the police, and the tiny part of the police budget allocated to dealing with fraud, and the frankly minute number of prosecutions. And that's obviously bad news for the national economy, because fraud is thought to cost us nationally annually something like £219 billion a year, which is roughly the same as we spend annually on both the NHS and defence budget. And it's also bad news, clearly, for victims of fraud. Equally, however, this lack of resources and maybe this lack of investigatory appetite to deal with these kind of cases is a recipe for disaster if you happen to be charged with an offence of fraud that may not have been investigated with all the rigour and the care and understanding that such cases need. Against this rather bleak background, it seems to us in Chambers it's really important that professionals working in this sector share knowledge where we can. Some of the concepts we're going to be talking about tonight, dishonesty, corporate liability, issues to do with confiscation and civil recovery, they pervade many different areas of law, crime, regulatory, commercial. I think our advocacy team in Chambers, our criminal team, is pretty unique in that we are a good sized criminal team in a larger set with a thriving commercial and insolvency team. And we found that this offers real opportunities for cross-fertilisation of work and a real depth of knowledge. So that's the service we hope to provide to all of you, to be real legal specialists apprised of some of the real challenges in this area. And this seminar is one part of that. But that is surely enough of the adverts. Let us get on with the show. Our first speaker tonight is Nick Lee. Since coming to the bar in 2018, Nick has developed a practice that encompasses regulatory work and traditional crime, along with a particular emphasis in fraud. But before coming to the bar, Nick worked in the banking and investment sector. So he'll permit me to say, if anyone can tell us what dishonesty means, it's surely him.
Thank you, everybody, for attending this evening. Dishonesty is obviously a core element of many fraud and white-collar offences, and everybody present on the call will know that the way in which juries are directed to approach dishonesty changed in 2017 through the case of Ivy, which moved us away from the test that had been set down in Gauche. So the purpose of this talk is to look back at that decision, consider some case law post-Ivy, and reflect on the significance of that change 7 years on. So with that in mind, there are three topics that I'll address. The first is a reminder of what changed when we moved from Gauche to Ivy. Secondly, to review some recent case law from different contexts. And finally, to offer some reflections on what that tells us about how significant the change really was. So I'll start then with a reminder of what the position was before Ivy. And the test for dishonesty that many of us will have learnt at university was set out in the case of Gauche, a case that concerned a dodgy surgeon who had submitted invoices for work that others had carried out, but which he justified as a way of getting paid for the work he had actually done. He was convicted, The Court of Appeal dismissed his appeal, but set out a new two-stage test for dishonesty, which is the test set out on the slide. First of all, was the defendant's conduct objectively dishonest by the standards of ordinary, reasonable and honest people? And secondly, must the defendant have realised that ordinary, honest people would regard his behaviour as dishonest? So as you can see from the test, it had an objective limb first and then a subjective limb, and that remained the test for dishonesty through to 2017 when it was changed by the Supreme Court in Ivey. Perhaps before turning to Ivey, by way of a caveat on the gauche test, it was in fact comparatively rare for the jury to be directed on the second limb of the test, because it was a relatively rare case in which the question of whether the defendant realised that what they were doing was dishonest was really a live issue. So when assessing the impact of the change from gauche to Ivey, it's important to remember that the second limb of the gauche test, which Ivey got rid of, was not a particularly common direction in any event. But in 2017, the Supreme Court decided the case of Ivey and cast doubt on the gauche test. Now, Ivey was actually a civil case in which a gambler, Mr. Ivey, sued a casino for the £7 million he had won at a card game called Punto Banco. That was obviously a large sum of money, so before paying out, the casino had investigated and discovered that he had won via something called edge sorting. And the way that worked was that over the course of a night's gambling, Mr. Ivey and his associate had persuaded the dealer at their table to turn certain cards upside down in the deck by pretending that it was their superstition to do so after a winning hand. The dealer had obliged, thinking nothing of it, because the backs of the cards were meant to be identical, whichever way round they were. But Mr. Ivey had worked out that there was actually a tiny discrepancy in the printing, which meant that he could tell when one of those cards was coming up in the deck, thereby secure a small advantage, which over the course of a high rolling evening translated into £7 million in winnings. So having discovered that, the casino refused to pay out and Mr. Ivey sued, with the claim eventually reaching the Supreme Court. And Mr. Ivey accepted that he had been edge sorting, but said this was not dishonest, leading the Supreme Court to consider the proper construction of dishonesty. And in comments that were obiter rather than part of the main judgment, the Supreme Court expressed disapproval of the gauche test and suggested that the test for dishonesty should be as follows, with the test set out on the screen. First of all, what was the actual state of the defendant's knowledge or belief as to the relevant facts? And second, once his actual state of mind has been established, was his conduct dishonest according to the objective standards of ordinary, decent people? Now, in this formulation, the subjective question comes first, followed by the objective question. And the biggest departure from the gauche test was getting rid of the question of whether a defendant must have realised that what they were doing was dishonest. Of course, a strong subjective element remains in the test when determining the state of a defendant's knowledge or belief as to the facts, but once that has been done, the question of dishonesty itself is determined purely by reference to whether that person with that state of knowledge was acting dishonestly according to the standards of ordinary and reasonable people. Now, on the face of it, that was a significant change to established case law. So why was it necessary? Well, the court gave a number of reasons, which you can see set out on the slide. I won't read all of them, but we'll just pick out one, which is that the gauche test had created a situation in which the more warped a defendant's own standards of honesty, the more likely it was that he would be acquitted, which was clearly counterproductive. So, having refreshed our knowledge of the transition from gauche to Ivey in that way, I want to turn now to some recent case law on dishonesty. I'll start with the case of Barton from 2020. The trial judge in this case had applied the test set down in Ivey. The defence appealed on the basis that the gauche test was still good law because the comments in Ivey had been obiter rather than leading. but the Court of Appeal confirmed that the test in IV is now to be used in all criminal cases. There isn't a great deal else to say about Barton for the purposes of this presentation. The key point is simply that it confirmed IV is now the test in criminal cases. And the next series of cases look at dishonesty in particular contexts. So first of all, the case of Wiseman from 2023. And Mr. Wiseman was a pastor at a Pentecostal church who marketed online a mixture of water infused with herbs and holy oil and claimed that this combination of spells and smells could cure COVID. And this miraculous cure was yours for only £91. And Mr. Wiseman's evidence at trial was that he believed he had received a commandment from God and that his fervent religious belief meant that he genuinely believed in the effectiveness of this cure. He appealed to the Court of Appeal after his conviction on the grounds that in the circumstances of his case, the judge should specifically have directed the jury to take his religious beliefs into account when considering the first stage of the Ivy test. What was his knowledge or belief as to the relevant facts? The Court of Appeal rejected that, saying that religious belief did not require special treatment under the Ivy direction, and that defence counsel had adequately addressed the jury on those points when closing, so the appeal was dismissed. Points of interest from Wiseman are that, first of all, in most cases, the Ivy test is a streamlined, straightforward test which rarely needs complication. But even in its most streamlined form, it provides plenty of scope for defence counsel to range over other factors relevant to the defendant's knowledge or belief when making their closing arguments. And the second point of note is that there's no dispute in the judgment that the defendant's religious belief was indeed a relevant factor to consider. So the case reminds us that the question in Ivy is what the defendant genuinely believed to be the case. And so long as that belief is genuine, Ivy does not require it to be reasonable. Turning then to a different context, in Datsun from 2022, not fraud under the Fraud Act now, but instead the fraudulent evasion of duty payable. The circumstances of this case were that the defendant's home had been searched, various legal cannabis products had been found, but he was charged with the fraudulent evasion of the duty payable on those imported products. And Mr. Datsun's defence was that he had genuinely believed that no duty was payable on those products, and a preliminary ruling was sought from the trial judge on whether that afforded him a defence. The trial judge had ruled that it did not, as it relied on ignorance of the law. Guilty pleas were entered, and Mr. Datsun appealed. On appeal, the Court of Appeal found that where the prosecution's case relies on fraudulently doing something, here evading duty, the prosecution had to show dishonesty under Ivy, and that the Ivy test, once engaged, specifically requires examination of the defendant's genuinely held beliefs as to the facts. So the Court of Appeal said that what the defendant believed the law to be was indeed a question of fact that the jury should have considered. So on that basis, the defence should have been left to the jury, his appeal was allowed, and his conviction was overturned. Points of interest from Datsun are that, first of all, Ivy concentrates our attention on the defendant's belief as to the facts in a way that Ghosh had not done so expressly. It's possible that the issues in Datsun would not have emerged so starkly under the Ghosh test. And secondly, is that dishonesty offences are a rare example where ignorance of the law can, in certain circumstances, be a defence, something that is worth bearing in mind in all sorts of white-collar contexts, especially when we also remember that a defendant's belief as to a relevant fact does not have to be reasonable under Ivy, it just has to be genuinely held. The final strand of post-Ivy case law that I wanted to address briefly is the case law relating to the LIBOR litigation. Now, LIBOR may be familiar to some of you, either through your own practices or as a news item, because it was one of the few scandals emerging from the financial crisis that actually reached a criminal court. LIBOR stands for the London Interbank Offered Rate, and it was one of the most important benchmarks in financial markets, and billions of pounds worth of trades and loans used to depend on it daily. The way in which LIBOR was calculated each day was based on a number of panel banks' own estimates of what they would expect to pay when borrowing money from each other. And the reason that is interesting from a fraud perspective is that tiny movements in LIBOR from day to day could massively benefit individual traders within the panel banks because it impacted on their positions across products that were priced by reference to LIBOR. So it created an incentive to low or highball the submission for their personal gain. And secondly, LIBOR submissions were done by estimate rather than by reference to hard data points, leaving it open to abuse. And it was effectively an open secret on financial markets that submissions were being shaped by commercial interests. So that's, of course, a very simplified overview. But in the aftermath of the financial crisis, the LIBOR submission process was investigated and a number of people were prosecuted for manipulating it. And there is now a series of cases from the Court of Appeal considering different issues raised in those trials. From the overview I've just provided of the LIBOR process, you might be able to see that it's one of those unusual contexts in which a defendant could argue that even if he had submitted a dodgy rate, it was not dishonest to do so in the prevailing circumstances because everybody was doing it and it was encouraged by senior management. Now, a man called Tom Hayes has become the unfortunate poster boy of LIBOR, so I will focus on his cases. His trial took place before Ivy, so it was decided under the gauche test, and one ground of appeal was that the jury should have been directed to take into account the prevailing standards and expectations in the market when deciding the first limb of the gauche test, i.e. whether his behaviour in submitting rates designed to benefit his own position was dishonest according to the standards of ordinary and honest people. The Court of Appeal gave that short shrift and stated, it's in a quotation, "The history of the markets has shown that from time to time, markets adopt patterns of behaviour which are dishonest by the standards of honest and reasonable people. And in such cases, the market has simply abandoned ordinary standards of honesty. Each member of this court has seen such cases and the damage caused when a market determines its own standard of honesty." So that principle, in my view, would extend to the second limb of the Ivy test, such that a jury should not be directed to take into account a market's own particular standards when deciding whether a defendant's conduct was dishonest. The benchmark remains that of ordinary and honest people. You can also see on the slide a 2024 case bearing Mr. Hayes's name. That case was decided last month following a reference by the CCRC. The appeal was refused. The tension between the gauche and Ivy test was not addressed directly, so I won't go into the details of that judgment, but it is there should you wish to take a look. The final case on that list, Hussain versus the FCA, is introduced as a point of difference. This wasn't a criminal case. It was an appeal by Mr. Hussain to the upper tribunal against a finding from the FCA that he was not a fit and proper person to work in a firm regulated by them. In comparison to the jury in Mr. Hayes's trial, the FCA, the Financial Conduct Authority, applying the Ivy test to Mr. Hussain's conduct, had found that he had not acted dishonestly in relation to LIBOR, even though his submissions were intended to be advantageous to his colleagues' positions. The FCA's finding that he was not a fit and proper person had instead come from how he had misled them during the investigation, rather than from his underlying behaviour. But on the question of his LIBOR submissions, the FCA had accepted many of the points that Mr. Hayes had argued in front of a jury, For example, that Mr. Hussain had not received formal training on the process, that there were a lack of formal procedures governing LIBOR submissions, and that there was a culture within the business which encouraged unrepresentative submissions. So it's an interesting comparison. And of course, any comparison has to be caveated by the fact that every case is different and these cases arose in different jurisdictions. But it suggests that a tribunal made up of people familiar with, or perhaps compromised by, a particular industry may be more forgiving when assessing dishonesty under Ivy than a randomly selected jury. Now, I know some people attending this seminar have professional disciplinary practices, so that might be worth bearing in mind on that point. Turning then to the final slide and some reflections on the change from Ghosh to Ivy 7 years on. And the first observation I would offer is that Ivy might be a dog that didn't bark. What I mean by this is that in hindsight, Ivy has received very little resistance, despite arguably going against Parliament's explanatory notes to the Fraud Act 2006. The reason for that is perhaps that, although it looks like a significant change, in practice it probably wasn't. Most juries know dishonesty when they see it, and the new test is easier to understand. In hindsight, it looks like a common sense and effective development of the common law. The second observation is that Ivy focuses attention on the defendant's knowledge or belief regarding specific facts in a way that Ghosh did not do so expressly. In Ivy, the full direction is almost always given, unlike in Ghosh, so the subjective state of mind of the defendant is front and centre to the jury's legal directions. That opens up tactical considerations, such as when to argue for legal directions that include a series of questions for the jury to answer to establish a defendant's knowledge or belief of various relevant facts. There will be many cases in which that isn't necessary, but in some more complicated cases, it may be advantageous to a defendant if he can win a series of smaller battles on particular facts before the jury moves to the overall question of dishonesty. And the final reflection is that it is worth acknowledging the trend towards reckless liability in many white-collar crimes. Mary will in fact address one such area later when discussing the Economic Crime Act. So with that trend, there are an increasing number of offences in which dishonesty per se will no longer be the critical question. Thank you very much for your attention during the presentation. I look forward to answering any questions you may have at the end of the seminar. But first I will hand over to Alistair on criminal confiscation and civil recovery. Alistair is an established criminal practitioner covering offences of all levels of seriousness. He is a grade 4 prosecutor, and for anyone unfamiliar with the CPS grading system, there is no grade 5. And alongside general crime, he has a specialist practice in health and safety and environment agency prosecutions, which often raise complicated questions of confiscation and recovery. So with that, over to Alistair.
I'm going to talk about proceeds of crime, and POCA is a very big topic. The Proceeds of Crime Act has hundreds of provisions, and since it was introduced over 20 years ago, has been the focus of numerous reported cases. You'll be relieved to hear that I'm not going to attempt to deal with the whole of POCA in one talk. Instead, the focus of this talk will be on a couple of discrete topics under the umbrella of criminal confiscation and civil recovery, with a view to looking at how they've been applied in practice. So criminal confiscation is something that we are all familiar with. It almost inevitably arises in fraud cases, but also in regulatory cases where the offender has benefited financially from breaching regulations or permits, and in a range of other criminal cases, perhaps most obviously and frequently in those involving drug supply. I'm going to focus this part of the talk on the question of what is recoverable in criminal confiscation, what is the available amount. Under Section 6 of the Proceeds of Crime Act, the court first determines the offender's benefit, either from general criminal conduct, if it finds he has a criminal lifestyle, or from particular criminal conduct, where the focus is solely on the benefit derived from the specific offence. Once the benefit has been decided, the question arises as to what is available to the offender. What can the court order the offender to pay to satisfy a confiscation order? For those who prosecute, it's important to know what can be captured in confiscation. In effect, what is up for grabs. For those defending, your client needs to be advised as to what assets and what property can be taken away from him by POCA. So the Proceeds of Crime Act provides some guidance on what property is available. Under Section 9 of the Act, the available property is the total value of all the free property held by the defendant. Value is defined in Section 79. It depends upon the defendant's interest. If he holds all the interest, then the value is the market value of the property as a whole. And market value can include an illicit market, for example, in valuing drugs. And then there's Section 84, which defines free property very widely. It includes money, all forms of real or personal property, and things in action, and other intangible property. The section also stipulates that property is held by a person if he holds an interest in it. So what happens where there were multiple interests? Unsurprisingly, there are occasions where a defendant has an interest in property which is jointly held with others. Where there are multiple defendants who have an interest in property which is jointly obtained, the confiscation order should record the full amount as being available to all defendants. And that was the case in the case of the Crown and Armoured and Fields. And that concerned two distinct cases which the Supreme Court considered. The first of which, Armad, was a carousel fraud. And in both those cases, multiple defendants had jointly obtained property. The Supreme Court held that each of the appellants had benefited in the full amount. There was no need for an inquiry into which share should be apportioned to each defendant. But the same sum could not be recovered multiple times, so the confiscation orders made against each defendant have to reflect this. Now, there's some scope for difficulties with this approach. For example, a scenario in which there are separate trials in relation to a large conspiracy and confiscations resolved in relation to the first trial before others are tried. The defendants in subsequent trials may not be required to pay as much as the first tranche of defendants, or even pay any amount at all if the full amount has already been satisfied in the early trial. The Supreme Court considered this in the Armoured and Fields case and did not really commit to an answer. They simply said that the losses must lie where they fall. Where property is jointly held with an innocent party, the court must assess the value of the defendant's personal interest. That most commonly arises with jointly held mortgages. As was the case in the case of Mogiri, the appellant there had a 1/4 share in a house he owned with his brothers. The brothers didn't want to sell, but the court held that the 25% share was property available to the defendant, and that in the absence of other assets to satisfy the confiscation order, the court could order the sale of that property. A tricky subject historically has been that of pensions, and the courts have had some difficulties determining whether or not a pension fund can be included in the available amount. In Cornfield, which is a 2007 case, the court held that a pension fund which was only available to the defendant in the future was not to be included. But the position changed 3 years later in the case of Chen, which seems to be the settled authority now. The court at first instance in that case had included the defendant's 2 pension policies in the available amount. That was despite him having no right to access the pension until it matured, and the policy could not be assigned or sold. But the Court of Appeal held that the pension policies were free property. but there remained an issue as to their value. So the solution was for the prosecution to apply to the Crown Court to increase the confiscation order on the maturity of the pension. Such an application can be made under Section 22, which we'll look at shortly. The case of Asplin is a recent case that concerns the approach to be taken to valuing a pension for the purposes of determining the available amount. In that case, the defendant's pension fund could be transferred to a SIP, which enabled him to draw down the funds. But at the point of drawdown, he was liable to pay tax. The tax liability was unknown at the point the confiscation order was made. So the solution here was for the gross value of the defendant's pension to be included as the available amount. Once the defendant drew down the funds to satisfy the order, he'd then be liable for tax, and the onus was on him to apply to the court for a reduction in the amount payable under the confiscation order. In other words, reducing the order by the amount of tax liability. So what about money held in trust? Can an offender ring-fence money in a trust to prevent it from being confiscated? Where money is placed in a discretionary trust, an argument can be made that nobody has the beneficial interest and that as a result, the property is not available. So the first question to consider is whether there's actually a trust in law. That was the question posed in the case of Stannard, and the Court of Appeal held that various assets said to be held under a discretionary trust were available for confiscation. That was on the basis of the trust assets being under the sole control of the defendant. The concept of control and having control of those assets in that case was inconsistent with the concept of a discretionary trust. So in short, there was no trust. But even if there is a trust, the second question is whether the defendant has an interest in the trust assets. And in the case of Jack Walker, the respondent was a beneficiary of a trust, which also included his sister and his cousin. It was a trust made for grandchildren. However, the trustees were the ones who decided whether to pay or transfer capital to him and how to invest the trust funds. In other words, the respondent did not have a right to present enjoyment of any income. However, the court held that the respondent's vested life interest in 1/3 of the capital in that trust was sufficient for his share to be free property within the definition in Section 84. And so that was included in the confiscation order. I mentioned it already, but Section 22 quite often crops up in relation to the available amount because it enables the prosecution to apply to the court after a confiscation order has been made for a calculation of a new available amount. This arises where an offender has post-conviction and post a confiscation order acquired assets, often through a profitable business or via an inheritance. The presumption is that if the money becomes available, regardless of how, it is available for confiscation under POCA. We can see that in a couple of cases. The case of Leon John concerned an appellant who'd been involved in a serious car accident, and he received compensation for that. There was £13,000 in general damages and £10,000 in special damages. The Court of Appeal upheld the order made under Section 22, but drew a distinction between general and special damages. General damages were included in the new available amount. The Court of Appeal said that general damages could be recouped as part of the Section 22 order, but special damages were not included. And the case of the Crown and Robinson concerned an indemnity obtained by the appellant in the Chancery Division that was also held to be available to the offender and recovered under Section 22. Under subsection 4, the court has a discretion to decline to make an order under Section 22, or vary an order according to what is just, but typically the court will make the order. The case of Padder provides 5 factors for the court to consider when determining whether an order would be just. And those factors are the amount that's outstanding, the additional amount that's now available, the length of time since the original order was made. That's varied in different cases, but significant periods of time have nevertheless found to be just for the court to reconsider the order. The impact on the defendant of any further payment. And then the 5th factor is any other considerations. The court has quite a wide ambit in terms of what it can consider. So that was criminal confiscation and focusing on the available amount in that context. It's apparent that when it comes to criminal matters, the courts cast the net widely in terms of what assets are available for confiscation. But there is another means of confiscation, and that's via civil recovery. Unlike criminal confiscation, which existed prior to the introduction of POCA, civil recovery had no precedent. Before 2002, where there was no conviction, there could be no confiscation. Well, that changed with the enactment of Part 5 of the Proceeds of Crime Act. And since then, the ambit of civil recovery has grown, most notably with the introduction of unexplained wealth orders, and that was via the Criminal Finances Act in 2017. Now, unexplained wealth orders are a topic for a talk in themselves, but they, in essence, require the respondent to explain how an asset was acquired. And if the respondent doesn't provide an adequate explanation or provides one that's unsatisfactory, the asset will be considered recoverable property for the purposes of a civil recovery order. It's worth looking briefly at this stage at the origins of civil forfeiture, which were set out back in 1999 in a Cabinet Office report. That report makes clear that it's not intended as a soft option in place of criminal proceedings, but was instead intended to be reparative, so taking away assets which were not legitimate, and also preventative, taking away assets intended for use in committing crime. It was also intended to have an international element, so it enables the court to recover assets held in the UK, but which are derived from crimes committed overseas. So what are the circumstances in which civil recovery is deemed to be appropriate? Part 5 of the Proceeds of Crime Act specifically permits civil recovery regardless of what had happened in earlier criminal proceedings. In the director of the Assets Recovery Agency and Green, it was argued that it would be wrong to bring civil recovery proceedings where the criminal case arising out of the same facts had been stayed as an abuse of process. But the Court of Appeal disagreed. It didn't make it an abuse to pursue civil recovery to the High Court, even where the criminal case had been an abuse. In the case of the Serious Organised Crime Agency and Gale, a few years later, the argument there made by the appellant was founded on Article 6 of the ECHR and the presumption of innocence. The point being made there that civil recovery was inconsistent with the presumption of innocence where somebody had been acquitted. The Supreme Court disagreed, though. In fact, a majority of that court took the view that an acquittal did not actually establish innocence, and they noted that the civil standard is lower than that in criminal cases. And so the fact there being an acquittal did not in any way preclude civil recovery of the assets. The other clue as to the circumstances in which civil recovery is deemed to be appropriate, and as you've probably gathered, it's appropriate in a wide range of circumstances. That can be found in the Home Secretary and Attorney General's guidance from 2012. They set out a few factors where it would be appropriate. one of which is where it's not feasible to secure a criminal conviction. Another is where a conviction is obtained but no confiscation order is made. And also where the view is taken that the public interest is better served by civil recovery rather than criminal confiscation. It may be thought that there may be some scope for civil recovery to be pursued instead of prosecution. So if you're advising a client, for example, who may be prosecuted, to perhaps get ahead of the game by suggesting they could voluntarily have their assets recovered to the civil route, it's unlikely this would find favour, given that the initial foundation for this was to ensure it wasn't a soft option in effect. So where there's grounds for a criminal case to be brought, the likelihood is it will be, but civil recovery is in effect a fallback option where that's either not appropriate or where confiscation has not followed. And so, like we looked at the question of what's available in relation to criminal confiscation, again, it's worth considering the question as to what is available for civil recovery. Well, it's property obtained through unlawful conduct. That includes any type of crime, including summary-only offences, and crimes committed anywhere in the world, provided that the crime is also a crime in the UK. So it's similar to the test for extradition, that the crime has to correspond with that in the UK. And the courts have interpreted this in various ways in a couple of significant cases. One of these is director of the ARA and John. The question in that case was whether income from selling goods on a market stall, which was operated without a licence, was property obtained through crime. The court decided it was not. If the sale of goods themselves was not otherwise unlawful, then it was not property obtained through crime. But the court in that case were clear that that did not mean that unlicensed trading could never give rise to a civil recovery order. But in that case, it didn't. In the case of Oldham, the respondent there failed to declare his assets to his trustee in bankruptcy. He then used those assets to buy property, and that property was held to have been obtained by crime. The conduct of failing to disclose the information about his assets made that property criminal property. And then the director of the ARA and Green, the interesting point to take away from that case is that unlawful conduct needs to be set out in at least general terms, but the specific criminal offence does not need to be identified. But it also held in that case that a claim for civil recovery cannot be sustained solely on the basis that the respondent lacks the identifiable income to warrant his lifestyle. It may be said perhaps that where someone's lifestyle is completely at odds with their personal income, it may suggest that property has come through illegitimate means. That's not enough in and of itself, but in the case of Gale, which I referred to earlier, it was held that an inference can be drawn from lifestyle. Going to just look very briefly at interim receiving orders and freezing orders in the context of civil recovery. Section 246 provides an interim receiving order can be made for the detention, custody or preservation of property, and also for the appointment of an interim receiver. And then section 245A provides the property freezing order can be made which specifies or describes the property to which it applies and prohibits any person from dealing with it. And we see that in criminal confiscation matters as well, where property is frozen. And like in criminal matters, an application for an order may be made without notice if there's a risk of dissipation of assets. Applications without notice are typically determined on the papers. Reasons should always be given, and the person applying for an order is under a duty to make full and frank disclosure of all matters which might undermine or would be advanced by the respondent if the application were not ex parte without notice. The power to make these orders is discretionary, but there needs to be a good arguable case. And that was defined in the case of Sepitovsky as beyond merely speculative. Now, the Serious Organised Crime and Police Act in 2005 inserted provisions which allowed exclusions to be made to these orders in order to pay legal costs. That came about because there'd been a case where somebody had legal aid, despite the fact they had assets frozen, which could have been used to pay their legal costs. So now there's a way in which that can be ring-fenced from the property that's frozen. The process for that is that on application or by consent, the court will earmark an amount for exclusion on the basis of prospective cost budget. And the court must identify a maximum amount to be ring-fenced at that stage. In the first instance, the court will normally exclude a sum up to £3,000. That's for taking advice, preparing a statement of assets, and advice on applying for the order to be varied or set aside. If the order relates only to some of the individual's property, and the respondent has other assets which could be used to pay legal costs, the order should not make provision for any legal costs. So if he has other money available to him, then no money is ring-fenced from that that's being frozen or subject to the interim receiving order. Now, the interim receiver, who's appointed under the interim receiving order, has a wide range of powers. The court can permit him to take any steps which are deemed necessary to establish whether the property subject to the order is derived from crime. That includes the power to require a person to answer any question. Now, as the answers to those questions are not being used in criminal proceedings, this is strictly civil, it seems that the privilege against self-incrimination does not apply. And so if compelled to answer any question, the impression one has is that they will have to answer those questions. And then under section 266, if the court is satisfied that any property is recoverable property, it must make the recovery order. That is unless an exception applies, and there are a number of exceptions that have, at least in theory, been found to arise. The first of these is detriment, which has been described in the case of Sarnham and the National Crime Agency from 2015 as essentially a statutory proprietary real estoppel. So it's a requirement that the respondent has not simply obtained the property in good faith, but has acted on it to their detriment. That case of Sarnham concerned a woman who'd been in an arranged marriage. She'd acquired a house via her husband who'd been involved in crime. She'd done nothing wrong herself. She simply lived in the house. But despite having some reservations, the court held that the order should still be made because although she had obtained the property and in good faith and had acted upon it, it had not been to her detriment. So there is a requirement for there to be detriment suffered by the respondent. But even that is then weighed against the claimant's interests in receiving the proceeds of crime. Another exception is under the ECHR. Again, it's at least a theoretical one because the court have considered this on several occasions. And the articles that are relevant to this really are Article 1 of Protocol 1 and Article 8, so protection of property and the right to family and personal life. The court's take on this, though, is that where assets are the proceeds of crime, they should ordinarily, as a matter of justice and public policy, be recovered. But the test is proportionality, and they have to weigh up various factors when determining whether it's just to make the order and whether it infringes people's article rights. The other exceptions perhaps go without saying. Multiple recovery means that the proceeds of the same criminal conduct cannot be recovered twice. In relation to civil claims, where in civil proceedings, in a conventional sense, there has been recovery and the civil recovery under POCA is based on the same unlawful conduct, the claimant cannot then recover, in effect, the same property. And similarly, where there's been criminal proceedings and that property constitutes part of a confiscation order following the criminal proceedings, it cannot be recovered twice. It cannot be recovered under civil proceedings as well. And then there's a victim exception. So a victim who claims that property belongs to him and was taken from him unlawfully may apply under section 281 for a declaration to that effect. And if successful, the property is not recoverable. So the obvious example of this would be a victim of fraud, where they want that money back. But the regime under section 281 is not compensatory. It merely protects the proprietary interest of a victim. And where the alleged recoverable property was depleted to allow for legal costs to be recouped, the legal costs are to be treated as being drawn from the recoverable property and not the fund subject to the section 281 claim. So in other words, where a victim makes a claim, their fund is ring-fenced. It's not to contribute any way towards legal costs. That's taken out of the money that's for the claim for recoverable property. And then insolvency proceedings as well. Civil recovery proceedings may not be initiated or continued in respect of property which is subject to insolvency proceedings without the leave of the court. That's under section 130 of the Insolvency Act. There are other limitations as well, most notably a 20-year limitation period. No proceedings may be brought more than 20 years after the cause of action accrued. But there is an exception to this if the respondent conceals facts necessary for a claim from the complainant. Time does not start to run until those facts are discovered. The final point to bear in mind with this is that under section 283, where a property freezing order or an interim receiving order has applied, but the property has not been held to be recoverable, compensation can be payable. So in effect, if you have your assets frozen under POCA, but then down the line either the claim is not pursued or the court holds that the property is not recoverable, then the person whose assets have been frozen can apply for compensation. There's a time limit of 3 months from the date of the decision, and if the court is satisfied that the applicant has suffered loss as a result of the order, it may require the enforcement authority to pay compensation to him. That brings my talk to an end. I appreciate I hadn't introduced Mary beforehand, but I'm going to hand back to Mary now.
My talk is about the Economic Crime Acts, and you will see from the subtitle on the slides, which I hope you can see, that I think there is something important to see here in terms of how this new act will change the likelihood of companies being prosecuted. Nick, I wonder if you could just give me a little thumbs up in the chat to indicate that you can see my slides.
Yes, we can.
Perfect, I will plough on. The Economic Crime Act was passed in October 2023 and it covers a wide-ranging number of topics, not all of which we're going to focus on tonight. We're going to look at the last 2 topics on this slide, corporate liability reform and the offence of failing to prevent fraud. But I've just set out here some of the other things that are going on in the Act for your information. The top 2, the amendment of the Companies Act 2006 concerning the registration of companies and the reform of partnerships, are both really picking up where an earlier act left off, the Economic Crime, Transparency and Enforcement Act of 2022, which was effectively passed in reductive summary to stop Russian oligarchs from laundering money in the London property market in the wake of the invasion of Ukraine. This goes further. And both reforms are really targeted at making it easier to work out the ultimate legal owners of entities and to peel away shell companies and look behind offshore trusts. Other discrete areas that the Act deals with on our whistle-stop tour new powers in relation to crypto assets, so powers for the police to seize, sell, or even destroy such assets under the Proceeds of Crime Act, and perhaps no more of a signal of intent, new rules of court to come into force in relation to strategic lawsuits against public participation. But the two areas that I'll be looking at this evening relate to corporate liability, and they flow really from a Law Commission's options paper that was published in June 2022. And here we are with an act in October 2023, which is perhaps a measure of how seriously it seems the government is taking the need for reform. The terms of reference for the Law Commission included this to consider the challenges faced by the criminal justice system under the current law in relation to corporate criminal liability. So before we look at the new law, it's perhaps important to look at the problems with the old law, the perceived challenge that the Law Commission was trying to address and that this Act sets out to meet. And it all starts with washing powder. And that's not a euphemism for money laundering, but actual washing powder, and the case of Tesco and Natras, which was one of the bedrock cases in relation to corporate criminal liability. I will just briefly remind you of the facts, as they are instructive about some of the tensions and a bit fun. It was alleged that Tesco had committed an offence under the Trade Descriptions Act by advertising a washing powder on special offer when it was in fact full price. The store manager responsible for this outrage can little have imagined that their actions would one day be examined by the House of Lords. So it's relevant to know that it was a defence for Tesco under the Trade Descriptions Act if the unlawful conduct was due to the act of another, and if the company charged had taken all reasonable precautions to avoid that act. So following the slightly tortuous route of that through the courts, the Magistrates' Court convicted and said the manager was Tesco, which probably came as a surprise to him, but that's summary justice for you folks. The Divisional Court said no, they were two separate legal entities, but that Tesco was liable because they hadn't taken all due care to avoid the store manager from making a false statement. And the House of Lords ruled, no, Tesco is only liable if someone who represented the company's directing mind and will was responsible for the conduct. But unfortunately, each of the 5 law lords expressed themselves a little bit differently about what a directing mind and will might look like. Bit of a whistle-stop tour through the other cases on the slide. Weatherfoyle, the Court of Appeal, saying not every responsible agent or high executive, in their words, will make a company responsible. The civil fraud case, El Adju, Lord Justice Rose said the directors of a company are prima facie likely to be considered the directing mind and will, but potentially others could be due to delegation. And then we have the case of Barclays, an SFO prosecution. And I'm conscious that we have some people from the SFO on the call tonight, and I'm sure that my description of this case will not do justice to all the submissions in what was a very complicated case. But reductively, the SFO sought to prosecute Barclays in relation to a group of senior officials, and they really were pretty senior. One of them was the group finance director. That group of people had the approval of the board to do a particular deal that involved Qatar. It was alleged that Qatari investors were essentially being paid to invest in Barclays, so using Barclays money to buy Barclays shares to give the public a bit of a good news story. In the Crown Court, the judge held that Barclays had been deceived because the group finance director had lied to the board, and he thought Barclays wasn't liable, and he acceded to an application to dismiss, in fact. The SFO then sought to reinstate the proceedings via the voluntary bill procedure in the High Court. Their case was Barclays had allowed these officials to do the deal. The officials held delegated de facto authority from the board, even though they were not the board. Well, in the High Court, they said they were bound by a factual ruling made in the Crown Court that the board of directors were not, quote, mere rubber stamps or ciphers in respect of this deal. And the judge in the High Court found that the whole reason that the group finance director had sought to deceive the board was precisely because the board were the real decision makers in the deal. If they'd all been in on it together, there would have been no need for any deception. But in that case, Lord Justice Davis noted the real strength of feeling that it was becoming increasingly difficult to prosecute companies as they grew in size or became multinational. So you end up in a perverse situation where it's easier to prosecute small companies with straightforward structures, but really hard to prosecute larger companies where fraud might have greater consequences for shareholders or even a national economy. Well, the Law Commission asked to look at this, as I say, in 2022, certainly agreed with those sentiments and went as far as describing this idea of the directing mind and will, the identification doctrine, as an obstacle to holding large companies criminally responsible for offences committed in their interests by their employees. But that was in 2022. Back in 2018, Lord Justice Davis observed he was stuck with the law as it was, and if Parliament wanted it otherwise, it would legislate. And now it has. This is section 196 of the Act, and the headline here is, if a senior manager employed by a company acting within the actual or apparent scope of the senior manager's authority commits a relevant offence, the company will also be guilty of an offence. And note, it's an organisation of any size. It's not a large organisation. As we'll see with the failure to prevent fraud offence, it could affect any body, corporate or partnership. So if we just go through and define some of the terms before we get on to any discussion, what is a relevant offence? What is it that what kind of naughtiness could a senior manager get up to that might later become a problem for their company? Well, that's defined in Schedule 12 of the Act, which I've spared you on a slide, but it includes offences under the Fraud Act 2006, the Theft Act 1968, POCA, cheating the public revenue, VAT fraud, all the usual suspects. Who is a senior manager? Who does a company need to be worried about? Well, the definition is provided in the statute at subsection 4, which is on this slide, and it's a definition which is lifted from the Corporate Manslaughter and Corporate Homicide Act 2007. And it's interesting to look at the explanatory notes to the Act in relation to what they say in terms of getting something of a sense of the parliamentary intention here. It says this test will look at what the senior manager's roles and responsibilities are within the organisation. That is, the level of managerial influence they might exert, rather than their job title. This will have the advantage of providing greater clarity on the parameters of the legal test and will enable prosecutions to progress in more cases where senior level employees who do exert decision-making power are found to be involved in the offending. So very clear in the explanatory notes, Parliament very well aware that this is a substantial widening in terms of the scope of people who might come under the net, who might create a problem for their company, and that they think is to be welcome. There will be more prosecutions. Moving away from the directing mind and will focus, effectively a focus on the board of directors or perhaps a small group of people and their relationship with the board of the directors, that option of moving away from that to this new definition was in fact pretty contentious, the Law Commission found out when they asked people to respond to their options paper. The Fraud Lawyers Association thought in many ways it was a good thing and it might close the gap between prosecuting large companies and small companies and the tendency perhaps of some prosecuting authorities to go for low-hanging fruit. But interestingly, one Alison Saunders, ex-Director of Public Prosecutions, now I think of Linklaters, was against this and thought it was better to simply have a failure to prevent fraud offence to catch poor corporate culture. But she thought that the corporate liability should really be reserved for what you might call board level offences. Well, the government disagreed, and this observer thinks that there is merit in this. There is certainly merit in the clarity of definition and having a statutory definition of a senior manager. And it's interesting that 4A and 4B set out the different types of control that can be exerted. 4A, decision-making control, 4B, on-the-ground control. So someone who was in charge of executing the decisions of the board, but had enough discretion that they didn't need to run absolutely everything past the board, might still commit a relevant offence which would make the company liable. And a board couldn't insulate itself from liability by choosing not to know too much about how its senior managers interpreted its resolutions. So it might be thought this is, in the modern world, a more realistic approach to how companies actually make decisions and the complex way in which hierarchies work. The other words which perhaps jump off the page at you in terms of this slide and the reams of likely case law that may be produced are the words the senior manager has to be acting within the actual or apparent scope of their authority. What does that mean? Well, again, the explanatory notes may help us. It doesn't mean that the senior manager has to be authorised to carry out a criminal offence. Perhaps, obviously, that might be a conspiracy in any event. It would be enough that the act was of a type that the senior manager was authorised to undertake, or which would ordinarily be undertaken by a person in that position. And the explanatory notes give the example of a CFO who deliberately makes false statements about a company's financial position. Well, the company might be liable because it is the job of CFOs to make statements about a company's financial position. So no need for the senior manager to be seeking to benefit the company by committing the relevant offence. Although I would hazard that if they were stealing from their own company, they probably wouldn't be acting within the scope of their actual or apparent scope of their authority. But what's changed here? Well, it seems to me that the parliamentary draftsman in putting the example of a CFO in the explanatory notes has perhaps sought to be reassuring, but the reality is that if a CFO had done this even under the old law, that might well have been problematic for the company. But what's changed here is that this doesn't just apply to CFOs. If, for example, there was a senior accountant who was, let's say, looking after the London office of a business based in Hong Kong, and it was that senior accountant's job to provide accurate information about the turnover of the London office to their boss, to the CFO, to the board. Well, maybe under the old law, the company would have an argument, a la Barclays, well, the board has been deceived. But if the notion of the directing mind and will and the board has gone, the company can be held responsible for the actions of that senior manager. So it seems to me this act substantially and deliberately increases the number of people that any large company needs to keep watch over. This section, the sections dealing with the expansion of corporate liability, are in force now and have been in force since December last year. And we are promised that a forthcoming criminal justice bill will further expand this new identification doctrine from economic crimes to all criminal offences. But they didn't stop there. There is also an offence of failure to prevent fraud. And you might think that, in a sense, a company which fails to prevent fraud on behalf of its senior managers is going to come a cropper anyway under the new definition of corporate liability. But as we'll see, this offence, section 199, makes the company liable for failure to prevent fraud undertaken not only by any of its employees at any level, but anyone associated with the body. So the company will be guilty of this failure to prevent fraud offence if an associate commits a fraud offence intending to benefit the relevant body or any person to whom the associate provides services on behalf of the relevant body. And again, just pausing to do definitions before discussion. A relevant body in this offence is a large organisation, and we'll come on to the definition of that later on, but this offence will only catch certain companies, not all of them. If we look firstly at the definition of an associate, who is a person associated with a relevant body? Well, the definition is on this slide here, and it seems to me that this definition doesn't just include employees at all levels, but on my reading of it, company suppliers, because a supplier is a person performing a service for on behalf of the body. So if we look at 7B, that person would be caught, or the company would be caught rather, by the actions of that person, provided the supplier was acting to benefit the company. It's worth noting too, the Act only requires the associate to have committed the offence. So the prosecution, in order to prosecute the company for failing to prevent fraud, would have to prove that the associate had committed the offence, but they don't have to prosecute the associate. So if the associate has fled to Ecuador, the prosecution can still go after the company. So what does benefit mean? As we saw on the previous slide, the associate has to be intending to benefit directly or indirectly the relevant body or any person to whom services are supplied on behalf of the relevant body. Well, on that definition, again, if we think about the explanatory notes for this offence, they make it clear that although benefit isn't defined in the Act, it's a broad definition. It doesn't simply mean financial benefit. So, for example, if someone committed a fraud to cover up other unlawful behaviour and the benefit to the company was avoiding a prosecution, that would be a benefit under the Act. What about this notion of an associate doing things on behalf of someone to whom their company provides services? My example, rather than the explanatory notes, it seems to me if an accountant, and I'm sorry to suggest that accountants perhaps are particularly likely to be culpable, but if an accountant engages in fraud, not with the intention to help their firm, but to help out a client of the firm by making misstatements about that client's financial position, perhaps giving them an unqualified audit when they know in fact they don't have all the information, then the firm of accountants may be liable for the actions there. Without having to worry about corporate liability, as it were, on behalf of the prosecution. They will have failed to prevent their accountant's fraud. So this is broad. This is broader than the Bribery Act 2010, which had more restrictive definitions concerning benefits and advantages. So what's the defence? Well, Section 199 sets out a defence at subsections 3 and 4. And it's to do with procedures put in place to prevent associated persons from committing fraud. Burden of proof on the defendant company to show that it had such procedures in place as were reasonable, or that it was reasonable not to have any prevention measures in place. And that's for the defendant company to prove on the balance of probabilities. This section, Section 199, the failure to prevent fraud offence, is not yet in force. It will only come into force once the Secretary of State has published guidance on how bodies can put into place procedures to prevent persons associated with them from committing fraud. There is some draft guidance that's been sent to stakeholders at the moment, and it looks very much like the focus is going to be on risk assessments. So the steer is it might be reasonable not to have any fraud prevention measures in place, but it probably is never going to be reasonable not at least to have done a risk assessment. And you can't rely on your old assessments for the Bribery Act. You have to look again. So when that is finalised, I anticipate that's going to be scrutinised pretty anxiously, because one might think that an attempt to adhere to that guidance would be relevant for prosecutors making charging decisions about whether to go against a company for failing to prevent fraud. The definition of what a relevant body should be caused quite a lot of debate in Parliament, but the definition settled on was this: a large organisation should meet at least 2 of the 3 criteria set out on this slide. So just a few reflections at the end. As I said, it did provoke quite a lot of debate how wide that failure to prevent fraud offence should be, and it was a little bit dispiriting that the government thought it appropriate through its ministers to suggest that perhaps having this apply to all businesses might just create a quote field day for lawyers advising industry. That's perhaps a bit short-sighted. There's clearly a tension here. There's a concern on the part of government about saddling small and medium-sized businesses with a lot of work to do to demonstrate that they have adequate measures in place. But there's also a realisation that growth at all costs isn't necessarily a good thing. And growth is very much a political buzzword now. You can't open a newspaper without seeing some politician with a chart showing a line going up representing the economy and a bag of John Innes potting medium in the other hand trying to make some subtle point. But there seems to be a recognition that there does have to be oversight for business. What was perhaps missed in the parliamentary debate is that when you actually look at those sections that we've looked at tonight together, it's probably going to be easier for the prosecution in some circumstances to just go ahead and prosecute the company for fraud on the basis of corporate criminal liability. Because there is not an explicit defence concerning fraud prevention measures, and the size of the business doesn't matter. So that might be an easier way in for the prosecution, provided, of course, that a sufficiently senior manager is in the frame for committing the predicate offence. But even in respect of corporate liability, we've noted that the concept of whether managers were acting within the actual or apparent scope of their authority is going to be an important one. And you may think that prosecuting authorities will in reality take into account whether or not an employee had to get round really robust fraud prevention measures in order to commit their crime, or whether they could sort of do it and have it winked at by the company. The prosecution probably will look at that when deciding whether a corporate prosecution is necessary. Thank you all for staying with us to the end. Apologies, we overran. I know that Alistair knows a great deal more than that about civil recovery, so thank you very much, Alistair, for condensing things in that way. If anybody would like to ask a question at this stage.
Mary, Caitlin here. I was just wondering, you're talking about when you're talking about the Economic Crime Act and kind of the extent of the jurisdiction. I was just wondering, with these global companies, do you think it's going to be possible to prosecute companies when employees are abroad but they're British companies, or if they are employees based in the UK but ultimately, the companies that have been created elsewhere? I was just wondering kind of what's the global reach of this act?
Thanks, Caitlin. Yeah, that's a good point. So obviously the usual jurisdictional principles at common law is that a case that's got an element of England and Wales jurisdiction, but also an extra jurisdictional element, generally speaking, it will only fall within to be prosecuted in England and Wales if the offence has a substantial connection to this jurisdiction. And as people on the call will know, the Criminal Justice Act 1993 extended the jurisdiction specifically for economic crimes. So if a relevant event, so something you have to prove the offence, took place inside the UK, there is jurisdiction to try it here, even if not all the relevant events took place here. Some acts obviously have sort of saving provisions. So the Bribery Act is different and more limited and is focused at organisations formed in the UK or carrying on business in the UK. This act doesn't have those saving provisions. So it seems to me, from looking at the act and the explanatory notes, if the crime happens here, the company could be prosecuted wherever its headquarter was, and potentially, because of the kind of slightly inchoate nature of some fraud crimes. So if a representation was made but wasn't operative, so if a company based outside the UK tried to target people in the UK by phishing or smishing or vishing or whatever you like, that the fact that they made those representations to victims in the UK would be enough. That would qualify as the relevant event. So I think that the kind of broad jurisdictional rules would apply. It doesn't matter that whether the company is based in the UK or not, if that answers the point.
Yes, thanks. That's quite interesting.
Thank you. It's very noble of you to say. Alistair, can I just ask you really quickly? You talked about the A1, P1 rights of people. So people who, let's say, stereotypical example, but wife unwittingly married to drug lord. And you talked about the fact that the court had considered the European Court of Human Rights and that legislation. Can you tell us what did they actually say? I mean, it seems on the face of it unfair that at a lower civil test, someone is losing all their property when they haven't done anything. And even in the case you gave about the arranged marriage, they knew nothing about it and weren't on notice. How did they square that with that woman's rights to the property?
Yes, well, the issue there seemed to be that, in theory at least, there could be circumstances in which someone could avail themselves of that, but they decided that she had not, in her case, suffered detriment from her reliance on that. They accepted that she had obtained the property in good faith, that she believed it was a wedding gift, I believe, in that case. And so it seems the court does leave open the possibility that someone could establish a claim for that property, which meant it wouldn't be confiscated, but that would be extremely rare. I mean, it's hard to think of a case where someone would be more unfortunate to lose out on their home in that case. But the test seems to be it's a very, very high threshold. So in effect, if it's property that's come from crime, it ought to be recouped. And that's very much the presumption, it seems, in virtually all the cases. When I was researching for this talk, couldn't find one in which they had weighed an article right in favour of somebody, even where they'd obtained the property in good faith.
Right, so they're not willing to say we won't think about A1, P1 rights, but when they have, it's been to no avail, actually. That's useful to know. Well, if anyone does have any more questions, please do ask or pop them in the chat. Otherwise, I will move to a slide that gives you some contact details if anyone wants to get in touch with any of us or with Chambers later on to ask questions or for any other reason. Want to say thank you very much indeed for spending part of your Monday evening with us. I can say as somebody giving a talk, it's really useful to have the task of preparing a talk, because that exercise and thinking about some of the questions that might arise is really helpful. And it's really useful to have you on the call for that, and we expect that there probably will be some more thoughts flowing around as a result thereafter. You will be sent at some point, I think, a feedback form after this event. We'd love to have your reflections genuinely on how we could make these talks more useful to you and to your firm, whether in terms of the content that we're covering, the length, and apologies for that, whether you like the online format, whether you'd like something hybrid or in person or bespoke or with experts or with your team or whatever. So please tell us what you actually think. Don't hold back. But with that exhortation, I will close the talk and stop the recording. Thank you all so much for coming, and good evening.